Welcome back. This is going to be a key lesson in your overall trial skills course. In this lesson, we are going to talk about creating a case theme and theory, something that sounds very ethereal. Also, pretrial statements, which I think are some of the most important documents in your case, and closing arguments. Julie, welcome back. Hi.
Hi, Billie. I'm excited to talk about this subject because it's something that some, even lawyers, don't spend that much time on, believe it or not. And I think that it's a disservice to their clients when they don't. Some just have these set pretrial statements that they throw out in every case. They really don't tailor to each specific case, which I think you're really missing out on a huge opportunity when you do that, because the pretrial statement is an opportunity to talk directly to your judge. So if you're just using some boilerplate language, from my point of view, you're really missing out on a big opportunity. And then also, this concept of creating a theme and theory and crafting your closing argument, these are really deep trial skills. Okay. Lazy lawyers don't take the time to really do this stuff. I'm going to call out the lazy lawyers. Um, and so I know as LPs, this is a big deal, competing against lawyers. This is where you can really gain a big edge, especially against these lawyers who are burnout and who are just going through the routine of things. Okay. Billie knows what I'm talking about. We've seen it in the courtroom. Okay. So you can really be, people think, oh, years of experience are so valuable, and they are. But with the years of experience, there can be a loss of passion. And the younger lawyers can have a level of passion that can outweigh the experience because they bring so much more to the trial. And I just want to pause on that concept, Billie, and have you chime in on that if you have any thoughts, because experience isn't always what wins.
I mean, I absolutely agree with you. I 1,000% agree with you. And um, there are a lot of lawyers who don't take the time to prepare. Part of that is cost considerations for some people. It can be incredibly costly and take a lot of time to do this really well. And that might be an excuse that some lawyers would use to not take the time to do a great job. To me, this is why lawyers get paid what they get paid, is to do a good job in trial, and it's worth taking the time. But I agree with you. I've seen again and again and again, younger, less experienced lawyers show up with more passion and more preparation and win.
Yeah. So LPs, it's a tough road gaining these trial skills, but you do have a big opportunity to shine and to potentially win. So let's talk about case theme and theory. Um, One thing that I think everybody will remember is the O.J. Simpson trial, and they had an amazing theme and theory. They said, if the glove doesn't fit, you must acquit. Okay, so you see right in that sentence, it rhymes. It's so catchy. Now, number one, don't feel like you have to come up with some rhyming, catchy sentence for every trial. Like, that's totally unreasonable, and you'll look kind of cheesy, to be honest. But if you can come up with something that's memorable and powerful, yeah, use it. Like, be creative. But what we see in this, if the glove doesn't fit, you must acquit, is it's this tying together of the facts and the law.
Mm.
They're saying, look, the glove, this is a key piece of evidence in this case. And if it doesn't fit, then this is what the law says you have to do. And with your theme and theory, understand that you may not be able to come up with one thing for your whole case, especially if you're doing a divorce and you've got like property, spousal maintenance, decision making. I mean, there may not be one tying thread between each issue, but you can have a theme and theory for each one. Okay. You're not limited to just one. You can break this down. Look, property, it can be something as simple as they were married for 20 years, 50-50 is fair. When you come to property, you're usually looking at, the standard is equitable division. So it's generally 50-50. So the dispute would be if one side or the other is asking for something other than 50-50. Or there's a dispute over what's community and what's separate. There's nuances, there's different areas, but those are the main disputes in property. So your theme and theory is going to be crafted around that, you know. This is separate property because that's what the tracing expert shows, or whatever your evidence is. But you want to take what you're trying to prove and tie the facts and the law together into this theme and theory. And if it comes out into some creative, catchy sentence that sounds great, wonderful, go with it. But you don't feel pressure to create that. Now, what the theme and theory does is, again, this helps you talk to your judge in 1 to 2 sentences. I had a mentor in the law, John Churchill. He was an amazing attorney. And one thing he used to always say to me is, Julie, whoever makes it easiest for the judge wins. Like, there's all this complexity, and it's true. But at the same time, like, you want to spoon feed to your judge. And I'm not at all implying these judges are stupid or anything, but remember, they have hundreds of cases. You want to break this down and make this as simple as possible for them. So keep that in mind with this theme and theory, because that's one way for you to break things down and make it simple. Judge 50-50, and this is why, or, whatever your point is you're trying to make. Now, as you're crafting that theme and theory, it could be really helpful to start drafting your closing argument. How are you going to tell this story? You sit down and this is what your closing argument is. You want in a page or two. Okay. You need a break. You may start writing and write 5 to 10 pages, and you need to condense that down to a page or two and get really clear on what you're proving. What is your case about? What is your story? And you're going to tie that all in your pretrial statement. Your pretrial statement is long, okay? It can be separate, it can be a joint statement, but the main part of the pretrial statement is to clarify for the judge what's in dispute, what facts are in dispute, what facts aren't, and what legal arguments are in dispute and what legal arguments are not. And so your theme and theory, your case, all of that is going to go into your pretrial statement. And this all needs to be consistent. This needs to be a story that's easy to follow. And you also want to make sure that the case you're actually going to present at trial backs up your pretrial statement. Sometimes what I end up doing is, with there's stuff that I'm looking to prove, but I don't know if I'm actually going to be able to prove it, is in my pretrial statement, I'll say upon information and belief, and then make the allegation. I think it gives me more credibility with the judge, because I'm not going in saying, I'm going to prove these 10 things, judge. And then I come to trial and the judge is like, where's these 10 things? I'm saying upon information and belief, this is my understanding. So realize that you do have that as a tool in your toolkit. And these documents, this pretrial statement, your closing argument, these are not things you're going to want to leave till the night before. These are things you're going to want to be working on. The pretrial statements due 20 days before trial. Once you get a trial date, you're going to be able to take a lot of the casework you've already created from the case and put it in there. But again, I wouldn't wait till the night before. This is something I would really want to take some time crafting the words on, and put as much detail in as possible. And one final point here, Billie, on the closing argument. When you're drafting it, know that you may never be able to actually give this closing argument in the trial because of the limited amount of time. Sometimes, like, I'll have a 1 to 2 page closing argument, and maybe I'll get to give 2 sentences. Maybe I'll get 5 minutes. You just don't know. So, but when you know your case well enough, it doesn't matter, because when you get to that closing argument, you're ready to go because you've done all of this prep, you've listened to the evidence. But just don't get too tied to or disappointed if you don't get to actually deliver the closing argument, because if you've done your job, it's already in your pretrial statement, and your case that you've presented has already given your closing argument for you. So one last point on the closing argument, a final option. You can ask to do written closing arguments. If you're running up against a time limitation, and maybe you have some surprises that come up at the trial, and you want to be able to try to influence the judge in writing one final time, you can ask, hey, judge, I'd like to do written closing arguments on this. Can we have 10 days? And see what the judge says. So I just want to let you know that as well. That's an option. If you can't give it orally, there is that option to do it written. It does incur additional fees and costs for your client. So that's always another consideration as well. Sometimes I'm like, I don't want to spend another 3 hours of client money. I'm just going to, I'm going to ask the judge for 5 minutes for an oral closing argument. So anyways, Thoughts on that, Billie?
Yes, absolutely. So I want to take some time on each of these. So can you give some examples of the case theme and theory? Like
Okay.
some that I have used are like they're catchy, quippy, like he's always 10 steps ahead. That's a case theme and theory that I've used before. What are some that you've used?
Um, so with parenting time,
Mm-hmm.
I'll often want to tie it into the best interest of the child.
Mm-hmm.
So some sort of theme, maybe I'd say something like mom's request is right because mom's request is in the best interest of the child, or something to that effect where I'm making a powerful statement and then tying it into the law.
Mm-hmm.
Um, you know, Spousal maintenance. You could say something like, after 20 years of dedicating her life and allowing her husband to pursue his dreams, now it's her turn.
Mm-hmm.
And without the law, she doesn't get a turn.
Mm-hmm.
Again, it doesn't need to be long. It should be a sentence or two that brings it all together. Child support, accountability can be big. Um, something to the effect of, um, hiding money only hurts the child, and the guidelines don't allow for that.
Oh, that's really good. Those are some great examples. Really, really good. You're making your judge listen. Like there's something different about this case. I love themes and theories because they really, it's so easy for a judge to literally forget who are these people.
Yeah.
I rule 50-50 for every case. And so if you're saying, if your theme is these kids' needs are different. They're not like every other child. Their best interest is blank or whatever. You're trying to cement and put a pin in the judge's head. Remember these people. Remember this case. So I love that. Thank you so much. When people are drafting a pretrial statement, there are so many different types of pretrial statements. There are so many different ways that this can be drafted. In my opinion, it should be everything. It should be everything. It should ideally, it should link to the exhibits you want to use and the page number of the exhibit that you're referencing. So when you say, mom's income is X, I like to have in my pretrial statements a reference to what exhibit number and what page on the exhibit that fact needs to be. This is my outline and my entire case. If I forget something, it's in the pretrial statement. Like I really rely on the pretrial statement as the place I get to tell my story, the place I get to be organized, the place I get to refer to every piece of evidence that I want in. What do you think?
Yeah. The pretrial statement is so important, and use it as an opportunity to get your entire case on paper because you're going to have limited trial time. You won't get to everything, but you can refer back to your pretrial statement even if you weren't able to present the evidence at trial.
And it's hard to present legal arguments through witnesses.
Hmm. Right.
So, and maybe you have some tips on how to do this, but I find that it is hard to present legal arguments through witnesses. And so the time to do that is either in motions, which we'll talk about, or through your pretrial statement. Are there other ways that you do it?
No, the closing argument, the pretrial statement, sometimes objections bring in some of the legal issues. But yeah, that's it's the craft of presenting your case because, let's think of parenting time. That's controlled by the best interests of the child standards. And the questions you're going to be asking your witnesses are going to be about those standards to get that evidence out. So there is an ongoing connection, but then arguing those points within the best interest standards, that's going to be your closing argument in your pretrial statement.
Absolutely. So, and one of the ways that that comes up a lot is with regards to domestic violence.
Mm.
There in Maricopa County right now, judges tend to not consider domestic violence as contrary to the best interests of the children on their face, even though the statute provides that that if you can show domestic violence, that you are shifting the burden of proof, shifting the presumptions. And it's very difficult for a witness to articulate that.
Yeah, and that's where that pretrial statement is important, especially with something like the domestic violence statute, which is so long. There's so many different parts to it.
Mhm.
And that's where it could be really helpful to say, look, judge, refer to page 5 of my pretrial statement and you'll see the really developed argument on the domestic violence issue. And here are the facts I just presented through this witness to support that argument. And then you can move on and the judge can review it later. But yeah, this is challenging work. And the more time you put into preparing and thinking about your questions and your evidence and what you're proving, that will really serve you.
And do you start, final questions here, do you start by writing the closing argument? And at what point do you do that?
I do start there. I'll generally draft my pretrial statement first, and that helps me start crafting the closing argument. But as I'm going into the real trial preparation phase, I'm drafting that closing argument to really get clear, what is each witness proving? What am I bringing out with them? How am I showing this? And just really taking these concepts that are in my head and putting it all together in one place and in one story. So you could do it before you draft your pretrial statement, but like I said, I like to draft the pretrial statement first because it starts to bring out a lot of the different points and gets me really prepared to start crafting the closing argument, but you could do those in either order.
Thank you so much, Julie. Next up, we're going to talk about drafting a trial outline, determining who you're going to use for witnesses and exhibits, and preparing those witnesses to testify. It's going to be a slam session. Thank you so much, and we'll be back soon.